City.
Diversity is very, very diverse. 5 women, two males. Good balance of African Americans, and one person born outside of the United States.
I'm ready, yes. Sorry.
On June 23, 2026, and I call to order the June session of the Rental Program Special Magistrate proceeding. My name is Robert Riggio. I am serving today as the Special Magistrate, and I will be hearing the cases that come before us. There are 2 cases and then a number of miscellaneous business matters, so just for those of you who are there, the general practice here is that when I call a case, if you could come forward to the lectern, it will be on your right side, and the city inspector will be on the left side. The city inspector, you will then be sworn in as a witness because everything here is all testimony is under oath. Following that, the city inspector will give the particulars of why the matter is being brought, and you will be given ample time to address anything that you wish to put in there, defenses, or if it's the wrong property, and that has happened once, and anything else that you feel is relevant. I will take all that into consideration, and then I will make a decision based on that information that is presented to me. Do we have any announcements?
No announcements.
Okay. I have approved the minutes of May 26th, and I've also have a satisfaction. Okay. And that gets us to item 3, approval of the minutes, and I have approved them. Now we'll get down to the hearing of cases. These are all irreparable and irreversible, which means that they are, the city has taken the position that these are the types of cases that may warrant significant fines. And they are of such a nature that, unlike typical code enforcement, they can't be the actions that gave rise to them cannot be undone. All right. Case number 1 is RTL 06-2617. The respondent is Alejandro Montoya Prieto and Amanda Sardinas Sevillano. They are cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 962 Country Club Avenue. Do we have someone present on behalf of Mr. Prieto and Ms. Sevillano? Good morning.
Yeah.
Are you?
Morning.
Good morning.
Good morning. My name is Amanda Sordino Sevillano, and my husband here by my side is present Alejandro Montoya Prieto. And with your permission, I will speak on behalf of both of us.
Okay.
Okay.
You need to be sworn in if you're going to give any testimony.
The staff needs to be sworn in as well.
Oh, I always keep. Yes. Can we swear in the staff who will be providing testimony this morning?
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? I do. Thank you.
Yes.
Okay. And we will need to swear in the respondents.
All right. If you each can state your names for me.
Amanda Sordino Sevillanos.
Alejandro Montoya Prieto.
Thank you. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you.
Okay. All right. Mr. Yates.
Case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations than short-term rentals are not permitted in this zoning district. The violation was first observed May 21st, 2026, and they were notified the same day. The property stopped actively advertising as of May 22nd, 2026. The daily posted rate was $411. The check-in time was shown as 4 p.m., the checkout time 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
All right. Ms. Diaz, do you have anything that you wish to
I
add?
do. Apologies. I was. I'll read through the city's position into the record regarding our stance that the city's position is that the beneficial gain to the property owner whose advertising conduct that is prohibited by city's code is unlawful and pursuant to Florida statute 162.06 subsection 4 is irreparable and irreversible. The effects of renting out a property as a vacation rental cannot be reversed. Once it's out there on the web, it can't be pulled back. The information has long-ranging effects in luring in patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertisement can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patrons and definitely to detriment to the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspection, proper licensing, proper insurance, and proper taxation required by law. Properties who have on staff on site 24/7 to address any emergency concerns that patrons or the community may have. I want to take a moment to focus on the people who are really being hurt by this unlawful Airbnb and vacation rentals, and that's really the community. The reason that we have such a strong enforcement stance on this is because we had an outcry from the community to the city commission to stop this behavior. We had once peaceful neighborhoods where families and children live and play outside, taken over by Airbnbs, and it caused an increase in crime. It caused an increase in noise. It destroyed the peaceful enjoyment that these residents are expected to have, that this community once had before the vacation rentals became a regular thing. So that is why we have a strong stance on prohibiting this behavior. One, to protect the people who have gone through rigorous regulations to ensure that they're safe for the patrons and for the community, and to protect the community's enjoyment of their neighborhood. Not only does it affect crime and noise, it affects parking, density. It's just something that we can't allow to continue. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against lawful accommodations, businesses, and lawful vacation rentals. The transient nature of the rentals limit the means of enforcement, typically to identifying advertisement, because by the time code enforcement arrives to the property, the transient patrons are typically gone from the property or claim a misleading relationship that are often contradicted by the advertised visitor comments. Accordingly, state law has adopted the city's defined vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these vacations are irreparable and irreversible in nature. Also, given the gravity of the violation, a fine of up to $15,000 is warranted pursuant to Florida Statute 162.09, subsection 2D. Thank you.
Okay. Mr. Yates, you have anything further?
No, Your Honor.
Okay. It's now the respondent's turn to say what they wish to put on the record. And so Do you have any defenses or objections or comments you wish to make? Please, it's your turn.
Good morning. We, Amanda Sordino Sevillanos and Alejandro Montoya Prieto, respectfully submit this statement to provide context regarding this matter and to request consideration from the special magistrate. This was our first experience owning and operating a property for rental purpose. Prior to this property, we had never owned, managed, or operate a property as either short-term rental or long-term rental. When we purchased the property, we understand that short-term rentals were permitted and rely upon the information available to us at the time of the purchase. We followed the requirements established by the Airbnb platform, obtained rental insurance coverage for the property, and paid the annual property taxes associated with the property. Based on this action, we believe we were operating in good faith and in compliance with applicable requirements, and no time did we intentionally violate any city ordinance or knowingly operate outside of local regulations. As first-time rental owners and first-time hosts, we were unaware that additional local license requirements, zoning restrictions, business tax obligations, or other city-specific regulations apply to this type of rental activity. Upon receiving the notice of violation, we act immediately. We contact Airbnb, provide a copy of the city notice, request assistance regarding existing reservations, remove the listing, and discontinue all short-term rental activity. We also removed the property from other platforms and took a step to ensure that the property would no longer be advertised as a short-term rental. I have documentation that demonstrates our efforts to comply, including communications with Airbnb, removal of the listing and cancellation of reservations, communications with the inspector, insurance documentation, and other records showing our good faith effort to address the matter as soon as I became aware of it. We have cooperated fully with the city of Daytona. We request guidance or support documentation to provide accurate record of our action. Any mistakes that occur were the result of misunderstanding the applicable requirements rather than unintentional disregard for the law. Once we learned there was an issue, we took immediate corrective action and worked diligent to resolve the matter. We respectfully ask the special magistrate to consider our lack of prior experience operating a rental property, our prompt corrective actions, our cooperation throughout the process, and our good faith effort to comply with the city requirements. Thank you for hearing me. Thank you for your time, consideration, and respectfully, Amanda Sardinas and Alejandro Montoya Prieto.
Okay. Does the city have any response?
We believe the fine is justified. However, we take no issue if you want to lower it.
Okay. The problem I run into is that when this type of item first came before me, I think it was about 5 or 6 years ago, this room would be packed full of people, and the city at that time was seeking the maximum amount of fines in the amount of $15,000, which is allowed by statute. And I have backed down on that over time. I thought $15,000 for somebody such as yourself and first time was significantly more than might be necessary to obtain compliance. And so I have backed down the fine over the years from $15,000 and now to about $1,000. And $1,000 seemed to fall within the realm of kind of a tipping point where someone could rent something, because these are usually fairly significant rentals, and it's a question of whether you back down even further and then have a room full of people who have all violated the ordinance. And I have searched for that tipping point, and it appears, unfortunately, that about $1,000 appears to be that point where we seem to exact enough of a penalty that the ordinance is followed, and there isn't a interest in maybe trying to avoid it and get a rental for a couple nights for $1,000 or $2,000 or whatever it goes for on some of these homes. And so I'm reluctant to reduce the amount of the penalty any further, having reduced it from $15,000 now down to $1,000. And so I understand your arguments. I also understand that, when someone ventures into a business, usually the first thing they should do is contact their local municipality, at which point they would have found out that what they are proposing may not be allowed where their property is located. And there's also abundant case law that says that you are on notice of ordinances in a city, regardless of whether or not you have sat down and read the code of ordinances. So I am going to impose a fine of $1,000 as requested by the city. And like I said, keep in mind, this is significantly less than just a few years ago the city was asking for, and was entitled to by statute. I'm trying to balance all of these equations together. So, therefore, I hereby find the respondents Alejandro Montoya Prieto and Amanda Sardinas Civillano in case number 1, RTL 062617, as the owners of the property at 962 Country Club Avenue, who have been in non-compliance of Article 4, Section 4.1a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and this property has subsequently been brought into compliance on May 22nd, 2026, and not violate, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. All right, we move on to case number 2, RTL 062618, Devontae Ho Hing is cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 108 La Costa, number 611. Good morning.
Go ahead.
Hi, good morning.
Go ahead and state your name for me.
Good morning. Hi, my name is Devontae Huhing.
And raise your right hand for me. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Sir, did I pronounce your name correctly?
Huhing.
Huhing.
Yes.
Okay. Okay. Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed May 28th, 2026, and they were notified the same day. 28th, sorry, May 28th, 2026. The property stopped actively advertising as of May 29th, 2026. The daily posted rate was $297. It displayed 5 reviews. The check-in time was shown as 11 a.m. to 9 p.m., the checkout 2 p.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz, do you have anything?
Did you hear what I mentioned earlier?
Yes.
Would you like me to repeat it, or do you mind if he just enters into the record for
That's
procedure?
fine. That's fine.
Okay. The city motions to enter into the record the city's position that these fines are irreparable and irreversible.
Okay.
Thank you.
That's fine. Therefore, let it be, it's my determination that the city's previous statements as to irreparable and irreversible relating to case number 1, RTL 062617, the city's argument that there is relating to the irreparable and irreversible fines be entered into the record for this case. And that just means that whatever Ms. Diaz stated before with respect to this is now made a part of this record. And you're free to contest anything you wish. That's just in the record, that's all.
Gotcha.
Okay. All right. Does the city have anything further?
No, Your Honor.
Sir, it's your turn.
Gotcha. Well, first, I just want to say, Ms. Diaz, I appreciate the information because this is my first time owning a home, and I just wasn't aware. I own an art production company, so I'd be out of town a lot of the time, and I just was trying to find a creative way to mitigate while I wasn't there, and I just wasn't aware. And I appreciate Mr. Yachts for the constant communication with us. So we went ahead and took everything down as soon as we could. We reached out to all the different platforms that we did put it on, have that communication as well. So, but I appreciate you guys for I didn't know the damage that was being incurred with it. I just saw that Airbnb was an option to do it, but I understand that the different zoning occupancies and everything. So yeah, I appreciate y'all.
Okay. City have anything further?
No, Your Honor.
Okay. Mr. Hu Hing, anything further?
No, that's it for the hearing.
Okay. You probably heard my statements earlier about the fact that I have been trying to reduce the fines for people who immediately come into compliance, and but there's still a lower limit that I have to keep this room from filling up, because several years ago this room would have been almost full of people who, like yourself, all said that they had no idea that there was an ordinance out there. And the attraction of trying to rent out a home, such as in your case where you're not there or what have you, is a good one. And this is a beachside community that attracts a lot of tourists. And does Airbnb put up anything on their website that says you should contact your local community first?
It says that it says you should be aware of all the laws, and you're saying you are when you sign up. That's their little blurb.
Additionally, with AI being so prominent nowadays, you type it into any AI platform or even Google for that matter, can I do short-term rental in Daytona Beach? And the answer populates as no, and cites our website that gives more details.
Okay. All right.
But we appreciate the compliance.
Okay, so as I said, Mr. Yates has asked for $1,000, and I feel it's appropriate under the circumstances. So therefore, I hereby find the respondent, Devontae Hu Hing, in case number 2, RTL 062618, as the owner of the property at 108 La Costa, number 611, to have been in noncompliance of Article 4, Section 4.1a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time that the violation occurs, and cannot be undone as provided for by Section 162.091D Florida statutes, and the property has subsequently been brought into compliance on May 29, 2026, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
All right. Thank you. Thank you.
Right. Okay, we now have 3 miscellaneous business items which all relate to 213 Jessamine Boulevard, but I want to take them up separately since each is on the agenda separately, but we have essentially the same respondent and the same zoning violations and the same issues regarding a lien which is imposed on the property. Is anyone here on behalf of Kenneth Metzler?
I am the realtor, Sarah Amarasinghe.
Okay, you're on that screen, not this one. Okay, I was looking
Hi,
over
you're
there.
on.
Okay,
Yes.
so the first
Good morning.
item then is RTL 02-2424, Kenneth Metzler.
Before we start, just for the record and procedure, can we have her under oath testify to her authority on this if she's not the property owner?
I think
Are you the?
if she is going to give testimony, she has to be under oath.
Yes. Has she been sworn?
No, not yet.
Oh, okay. I'm jumping the gun. After she's sworn, I just want her to state for the record her relationship to the property because she said she was the realtor.
Correct. But I first have to
Yeah.
read in the little blurb
Apologies.
relating
I
to the
apologize. I jumped the
property.
gun.
Okay. Okay, this is miscellaneous business number 1, RTL 02-2424, Kenneth Metzler Jr., who had been cited for violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 213 Jessamine Boulevard that pertain to short-term rentals. The respondent had previously been found to be in violation. An order and a fine order was issued and a fine was imposed in the amount of $15,000 on March 28, 2024. And since that time, the fine has amassed interest plus a recording fee and currently stands at $18,112.85. Okay, and ma'am, if I could ask your name again, please?
It's Sarah Amarasinghe with Jason Mitchell Real Estate Group.
Sarah, and your last name?
It's Amarasinghe, AMARASINGHE.
Armasinghe. Okay. Ms. Armasinghe, we'll need to have you sworn in if you're going to be giving any testimony in this matter.
Yes, sir.
Okay, go ahead and raise your right hand for me. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. I'd like to just sort of preface this matter with where I see this matter stands. Okay. This respondent has been cited for a violation of the city ordinance. A fine was imposed. There is a window in which the respondent can contest the fine, take it to circuit court. That was not done. Also, the particular violation is one which is considered irreparable and irreversible, which pertains to the actual actions that occurred as opposed to something that can be corrected. Yes, the respondent is supposed to stop, as these individuals here have done. In this case, we have 3 where the respondent A did not show up for the hearings and did not stop the activity that was the subject of the matter. So we have someone who had been unlawfully using their property, amassing fines, and basically ignoring this process for trying to resolve matters. And I'd also point out that these are considered to be they're somewhat different, and with respect to the issue of a lien review, which I don't think is necessarily applicable here, because typically the point of a lien review in a typical code enforcement case is there's a violation that can be corrected. In this case, the horse is already out of the barn by the time it comes here. And you can't put the horse back in the barn because the person has benefited from the illegal activity. So these are factors I'm taking into consideration that would be sort of generic to this type of situation. But Ms. Armithing, if you could present the case that, first of all, are you authorized to speak on behalf of Mr. Metzler?
Yes, he gave Lena from the city all the information on the documents showing that I was.
Okay.
He's in Pompano Beach.
We have authorization. I just needed her to say it for the record.
Okay.
Yeah.
I just want to make sure that we're dealing with everybody who can properly speak, and if we don't, then we'd continue it or whatever. But
yes.
If you are authorized to speak on his behalf, then please do.
Okay. From what my understanding is, I did a little research on it. Chris Metzler was the brother that originally owned the property, and he passed away. So they have a cousin or somebody that was, I think, staying or managing the property while he was in a nursing home, which he ended up subletting it without their knowledge. And then I think he was actually served in the nursing home, the guy that passed away. And Kenneth inherited the property. So during this course of time, Tracy from the historic district that I think used to work for the city or being on the planning board, she had some interest in the city. And then that was many years ago. She's now the head of the historic district and that Riverview school she's a part of some matter. So she's been complaining there was an Airbnb there. They were notifying and posting these, the postings on the property, trying to get a hold of the owner, but he was in a nursing home. Finally, I think before he died, he might have got some mail there. Then Kenneth inherited the property, and somehow there's just been more fines, but they never knew this was going on, according to what I'm hearing, because some guy, James Bowden from Grenada, the country, was the one that was doing this. And I know, that he isn't the owner. It shows the Airbnb host is James Bowden. And I mean, I even spoke to one of the neighbors, and it matched up that it wasn't the elderly people that own the property, the actual homeowner. It was James Bowden, the super host. And he kept taking down the notices, from what I understand. The owner has a $225,000 mortgage, and it's in the historic district, and it's just hard to sell. And if Tracy, the head of the historic district, wants to she kept complaining, I think even when it wasn't an Airbnb, to my knowledge, if I'm understanding correct. And it is furnished in there, but it's just for sale. It's not being rented at any moment now. James is not in the picture. But but it's really hard to sell. And if it's the preservation, if they want to preserve it for that Seabreeze district, it's hard to sell it and get someone to make that house nice again. It's a wonderful house. I just think it would really help getting it back to the shape it deserves to be in for that historic Seabreeze district. That's the reason, kind of, so we could get it sold and get it looking nice again.
Okay. Ma'am, if I can sort of paraphrase what I believe the argument is. Essentially, the house had been placed in the hands of somebody who was taking the notices and tossing them, so to speak.
From what I hear, yes. James Bowden.
Okay. And that service had been made basically by posting the property as opposed to any of the other ways of doing it.
It would have been sent certified mail to the address on file as well as the
Oh,
posting.
was it?
It received both, yes, sir.
Okay,
Your
so
Honor, sorry.
Yeah, it was just the main property address. For some reason, it was never changed, and the guy ended up in a nursing home.
so the city had done everything that is supposed to do by statute.
That's correct.
Okay, and that's why I'm trying to work through this. That being sort of, there's always an equity argument in these types of matters. And that the second part then is, well, that seems to be the crux of the argument. So if the city has a response, please, I'd like to hear that.
Yes, so under Chapter 162, we have different forms that we can give notice. The ones that we use that are delineated under the statute are, one, posting it in person by posting it like on the front door. Second, we also send it via certified mail. I also believe we post it in a conspicuous place like the City Hall.
Yep.
But when we send it via certified mail, we send it per the statute to the mailing address on the property appraisers. So if it was sent to the wrong address, that's because the owner didn't update the property appraiser's mailing address. So that's, well, we sympathize. It was a mistake that the property owner did by not updating the mailing address on the property appraiser's site.
Okay, well, the city has to be able to contact people. They can't go underground and disappear. And that's sort of what I see may be the sort of the issue here, is that there's a responsibility on people who own property, regardless of their situation, to provide a means of allowing the city to communicate with them if they have a problem. Now, there's also the problem of the property owner is supposed to be on notice, is on notice, yes. And there's abundant case law on that, of city ordinances. And so somehow this property is disappearing. It might as well be in another country. It's like they've decided to separate themselves from the city of Daytona Beach. And throughout this entire period, this property is being rented out, and somebody's making money off of this, if I understand it.
Yes, it was continuing to be rented during the time period.
If I believe I looked quickly at the past minutes, and I believe you had noted that there were lots of reviews, and so somebody's benefiting, and this is really should not be the city's problem. That track down people who fall between the cracks, so to speak, or, I mean, there have been situations where I believe that has been done purposefully. And so this is kind of an interesting, where now we have three of them all come together, and we have the person trying to sell the property, and I'm looking for something where I feel that I'm not setting a precedent to create other people from falling between the cracks and then emerging at some later date and saying, well, I made a fair amount of money off of renting this property, but at the same time, you had no way of letting me know, and that's sort of a property owner's responsibility. Ultimately, it comes down to the property owner. So I'm looking to the city as to what the city feels is appropriate under the situation.
The city doesn't believe the reopening of these cases would be appropriate in this case and that the ruling should stand.
Okay.
Can I just say something?
Please do.
I'm sorry. He died and he was in a nursing home, and then someone continued to rent it without their permission. And then during the whole process where they get the house, then the other brother and the mother, who's very elderly, I know ignorance isn't a reason, but I think they didn't know because he was in a nursing home. So the man died. There was no way he could change his address.
Okay.
And then this Tracy, from what I've heard, is she just kept complaining. So I don't know how many times James made money off of it, but it's not the owner of the property.
Well, he had control over the property. And that's the problem I have. Somebody who just gives the proper and says creates what amounts to a straw man, and the straw man can't be touched.
Yeah. I also would like to add that the actual owner of the property isn't here to testify. It would carry a lot of weight if the owner of the property was here under oath, under the threat of perjury, to say, it wasn't me, I didn't benefit from this, but the owner's not here. So how do we know it wasn't the owner, the new owner, like the son, the person who has it now that was doing this while the father was in the retirement home? It's just...
You guys have on paper, the thing that shows James, the super host, and apparently you guys set him up and actually stayed a night, is what I'm hearing, in the unit,
No.
from my understanding.
Oh, that would be entirely incorrect.
Okay, that's what I was told.
And see, that's
I'd
the
have
other
to get
issue
the public
here.
records requests.
Everything that's been stated isn't really a fact here.
It's
She's
hearsay.
stating that this may have happened, that may have happened. We have no time periods. There's nothing that really brings us back to show that at no point, basically this property wasn't being properly monitored, and that's why we're here, not for any other reason. Now, I can't speak to why they chose not to, but I don't believe any hard evidence has been presented to show that.
Yeah, and this inspector makes a really good point, right? Under Florida case law, there's numerous cases that say that hearsay is allowed in a quasi-judicial hearing such as this. So she's free to say all the hearsay that she wants. However, case law says that a finding can't be based solely on hearsay because it's circumstantial evidence. Hearsay needs to be corroborated by additional evidence, which hasn't been presented in this case.
Okay, I'm going down a sort of a separate avenue. I've heard testimony that somehow the city, through I believe it's historical district folks,
Yes.
has stated if I had something where ultimately this is an equitable matter, but there have to still be some hard facts that I base equity on, not simply, okay, there was somebody who owned a house and they chose to put the house in somebody else's control, and that other person just broke every violation they could, and they disappeared off into the distance, and now we've gone through the process of the community, as I don't know if you've heard Ms. Diaz state why this ordinance is being enforced, because these violations tend to create police problems, they create community problems. People who are down on vacation think that they can do anything, and if they're in a hotel or a motel or in a bed and breakfast, there's a manager who can go up and say, stop partying at 4 o'clock in the morning. But in these communities, when they get out in a residential area, they're free to do whatever they want, and it's a 24-hour-a-day party going on in a place where maybe the guy next door has to get up and go to work the next morning, and that's just wrong. And so, if there is somebody with the city who is willing to say, and maybe this is something that this person needs to talk with the city commission about at a meeting, that they have a home that they would like to see be transferred because it's in I'm told it's in a historical district, that they're willing to forgive the fines, then that's fine. I think I could give some weight to that. But right now, I can't give any weight. Everything's hearsay, as Ms. Diaz has said. And I have people who may have knowledge who are not testifying. And so my feeling, ma'am, rather than just outright denying this, I would think that it might be best to continue it and think about how you can put together something to answer the questions I have that I feel are relevant. And I think Ms. Diaz makes a very good point about I'm making a determination that there is a problem based on a lot of hearsay. I don't have any factual support. You've mentioned somebody with who is involved with the historic districts. If maybe that person maybe should go in front of the city commission and say, we've got a problem and we'd like to do this, and let the people who actually are elected to govern the city make a decision that in this case, maybe we should release these fines. Otherwise, I fear I'm gonna start seeing a whole lot of this. Because somebody at one time years ago tried some end run on it, and the next hearing, I had half dozen of them out there who tried the same thing. So I'm willing to continue it, but we have to come up with something that makes me feel comfortable that, in fact, this is not going to give rise to a way of avoiding this ordinance. I've got every one of the hearings, nobody shows up. There's no testimony, and now even the people who may stand to benefit from the sale can't bother to show up. And so, again, that's where I would like to go. Ma'am, if you would like to say something more, please do.
Yes, so thank you. On the public records request, I did get that information about Tracy from the city, from the historic district. And then, also public records for James. He was the super host, and where they've never served him other than the nursing home. So that was not hearsay. That was from public records requests from the city. And then he's trying to pull over to actually join the meeting if we're still here at that time, because he's driving at the moment. I asked the owner if he could please join.
I still think it would be appropriate at this point to continue it so we have a real record of this. And, you know, if we meet once a month.
Okay.
And if you could get that stuff together and coordinate with the city attorney's office maybe, or what have you. Because
I have it.
I understand the problem of a house sitting vacant, and you'd like to get it into somebody's hands. They can be responsible for the upkeep and all of the other things. At the same time, everything I have is hearsay right now. And if we could get honest to good, the city the city itself has an interest in trying to see this home be preserved, and this sale will help preserve it, then I can then make a decision. Okay, but right now I've got nothing to base a decision on.
Okay, may I ask what are the questions? Because it's not, I'm not disagreeing, but like the city just didn't supply you with the information, like the Airbnb superhost they gave me, and Tracy's information, the constant complainer from the historic district.
To
so
clarify,
that's not hearsay. That's actually on paper with all the public records requests. I only got a couple pieces of information, but I'll get all the public records requests. They should have given that to you.
It would help to some extent. I'm sitting in City Hall, and the folks who I expect would be the ones who could be up here speaking to this. I mean, it would take 5 minutes out of their day to walk up the stairs and come in here and say, we have an interest in trying to resolve this. And then I can see that the city has an interest in it, because this, again, is an equitable one. It's not one of just resolving it. It's one of the community at large benefits from the reduction or the elimination of these fines. Okay?
Can I ask one more thing? Ken Strickland helped me out a lot just to get through to you. It was very difficult. I was told I could not meet with you at one point, like, or couldn't continue to try to resolve this.
You can't
when
meet with
when
me.
I went.
I'm here to
No, I mean
hear,
like to get to this point.
to get to
this point.
When you get to this,
Yeah.
I cannot meet with the respondents or with the city. I can't discuss it with them as to what's appropriate. I'm supposed to be a neutral arbiter who's hearing it, but I'm also supposed to try to follow what I consider to be the law, and the law says that there has to be something more than a lot of hearsay. There has to be some equitable component that I can say, yes, this warrants a reduction, and then also helps me in determining what that is, because we had 3 separate hearings, and over a course of, I think, 4 or 5 months.
Yeah, I gave them a break in between to hopefully that they would stop.
And I assumed that the house is being rented out, and that was sort of a good season to be renting out, was spring, and when people, that's the spring break area. And I know that these types of homes, from the testimony, sometimes go for $1,000 a night. This could be
and it was
significant
generating
amounts of money
complaints.
was taken in by somebody. And so, and the possibility of that somebody making a significant amount of money and then saying, sorry, I'm the person who should have been responsible. First of all, the gentleman died, and I feel sorry for that. But there should be somebody who's looking through his effects and saying, well, why is this guy getting all of these notices from the city of Daytona Beach? Nobody wants to be responsible, and it's more like a smokescreen to cover up that somebody made a lot of money, and now they want to make even more money by selling the property. And that equity is crying out right now saying, this ain't a good deal for the city.
Mr. Riggio, can I address what she said
Yes,
about
please.
not coming before you? You asked for a lien review, and a lien review technically is something that comes into compliance. This case was something that couldn't come into compliance, so it's not technically a lien review.
But that's why we put it on the agenda as an appeal,
Right.
miscellaneous.
Correct, that's a
But
reconsideration.
I'm still looking at it using sort of some of the lien review type principles. I don't feel comfortable just saying, I waived this fine that's accrued, because the fine that accrued, Mr. Yates brought credible testimony that the property was in fact being rented out, that somebody was making a lot of money off of this. And at the end of the day, we just say, well, we waived the fine. I can see people lining up to do this in the future. And I'm not going to open the door to that.
Well, and this was a property that was actively generating complaints. That's what this
Okay.
Tracy person they're talking about is this person who was complaining about the property.
Okay, so we even have real complaints on top of it. It's been a while since
Yeah, no, it's an old one. I think it's 24.
yeah, I think so.
Yeah.
So, but that's what I'm looking for. I'm looking for something I can say, we're bringing resolution to a very unique, you have a very unique situation. You've got to get those unique factors so that I feel comfortable that when I have a respondent who ignores or finds a way to ignore the notices that are sent out for months on end, and then there's somebody else out there who's renting it out, and Mr. Yates would bring in each month, and there were new rentals. So there's more money coming in, that I don't open the door to basically an end run on the city ordinance. And I think you could discuss that with the city attorney's office. That would probably be good, or whoever, or the people down with the historic district. But I want to have something along those lines. And I understand. This is not. I've seen lien reviews before, but they've never been in a situation where nobody's taking responsibility for what happened. And yes.
That's the owner,
Okay.
Kenneth.
He will, if he's going to give some testimony, but I think at this point if you want to be sworn in, say a few things, that's fine. Can you swear
Hi,
in?
how are you doing?
Go ahead and state your name for me.
My name is Kenneth Stephen Metzler Jr.
Okay, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Sir, do you have something you wish to add?
Yeah, I think the issue is that I didn't make any type of monetary thing from this problem that's going on. I wasn't even aware that they were doing this at the house.
Mr. Metzler, I understand. And I think if you've been listening in on this, I'm amenable to doing something, but that alone is not going to satisfy me. Okay?
Okay.
He didn't hear anything, I don't think.
Okay. But
can
I'm amenable, but I think I've talked with your, with Miss
Amar Singha.
Amar Singh?
Sarah.
Sarah.
Amar Singh.
Sarah.
But because of the unique facts of this situation, I think that, and because of, understand this is a lien which is now actually a real lien. The opportunity to contest the underlying violations has passed. There's a 30-day time clock which ran out a long time ago. So now we're basically taking the entire thing, even though Ms. Amar Singh has stated, and I think Mr. Yates has stated, this place was being rented out. Somebody was collecting money. And so the violations were definitely occurring. And so I need to see something that says that, and understand something. Everybody is responsible for the property. Sir, if the gentleman passed away who owned it and you're the heir, you become responsible. Period. That is, I'm not going to make excuses to say that, well, you didn't know this or you didn't. No, you're responsible. The gentleman who passed away he should have put the property in the hands of somebody who was responsible. And all I hear is that there's a straw man out there who's collecting tons of money, okay, because it's being rented out a lot. And now that guy has now made off with it, and now let's just all sweep it under the rug. I'm not sweeping it under a rug, period. And I've talked with the realtor about a way of perhaps coming up with a way of trying to either reduce or whatever the amount of the fine, but that has to provide some value to the city, not just sweep it under the rug. Because as it stands right now, it is of value to the city because it's creating an impediment to you to sell the property. And I've seen a number of properties where eventually the owner says, I want out, and they sell it and the city collects their portion of the lien.
I understand all of that. Excuse me. I understand that. My real issue is that I never got a single notification of any of this. So I was completely unaware until I went to sell the property.
Can I answer that?
Ms. Diaz.
So under Florida state statute, you weren't the one we had to notify. We had to notify the owner, which we did. The fact that the owner didn't notify you is not something that binds us to do anything under case law, unless you could show me something different. But we did what we were legally required to do. It was on the owner to notify next of kin or the person who was managing the property. You knew your dad was unwell. Maybe you could have helped him with this managing of property. I'm not really sure, but you can't put that burden on the city because the law doesn't. So
it was his brother, and he was in a nursing home. I'm sorry, Kenneth, go ahead.
Your brother.
No, I understand that. But once again, where was these notifications sent? Who signed for these notifications? I still have not even seen one piece of paper that says anything was sent.
Let me handle this too. So again, I'm not criticizing you or saying what you should or shouldn't have done. But if my brother was sick, I would have updated his power of attorney, I would have changed the property appraiser's mailing address to my address because I would know that he wouldn't be getting mail. I would manage the finances so I know that someone was getting the mail. Leaving it for not, leaving hands off and hoping something gets to you without making sure it does isn't proper, responsible property ownership, right? If you knew your brother couldn't manage it, there was no other next of kin, you were the next of kin, it was on you to make sure that that property was managed. We told the property owner, and I just really don't understand the argument that you didn't know.
Okay, the problem is that
We
you keep
sent
saying.
it via, let me finish one more thing. We sent it via certified mail. We posted the property in person. And I also believe we did a sign at City Hall, all the things that the statute requires.
So just again, who did you send it to?
What was on the property
signed
appraiser?
for it?
What was on the property appraiser's website? The only address we're
So-
legally allowed to send it to.
Right, but I asked who signed for this stuff.
Sir, I think I've outlined a way of trying to resolve this matter
Okay.
with Ms. Amar Singh. I am not going to budge. The statute provides the way that the city provides notification. And there are multiple ways of doing that, and they did that. Okay? And in this case, I hate to say this, but the next of kin appear to have said, well, we don't want to know anything. Okay? If somebody is in a nursing home and does not have capacity, then that is not the city's problem. That is the next of kin's problem. And you all should have been monitoring and bringing this to a close. And I'm certainly understanding if someone had come forward and said, here's the problem. But instead, the property is turned over and put in the hands of, from what I've heard, someone else who was renting out the property and just thumbing his nose at the ordinance in the city of Daytona Beach. Okay? And I would like to see this thing brought to a close, but I would like to see it brought to a close on a way that is fair to all concerned and is not just sort of a windfall for the new owners of this property. So I'm going to continue this matter. Fact is, unless anyone has a problem, I'd like to continue all three of these to the, what would be our next hearing date?
July 28th, 2026.
July 28th. 26, okay. So, again, I've given instructions or ideas to your realtor of try to come up with something so that I know that the city isn't being snookered. That's what it comes down to. You can't, apparently someone, sir, was renting that property out who had authority to do that and wasn't sharing the money with you, or I don't know. I don't know what's going on. All I know is that for 4 or 5 months, this property was sort of like off the grid, and that's just unacceptable. So
Okay.
I have a question. I'm so sorry. What am I supposed to just provide you what the city already provided me with the information of James being the superhost and the complaints from the public records and the request for the fine reduction? Because these are all public records.
Oh, I understand. My suggestion would be, because oftentimes these matters have been discussed with city staff beforehand, to try to come to possibly come up with something, because basically what is being said is the city is saying we're willing to waive. What is this? We've got 18, 36, 36. $53,000 of fines, plus or minus, okay, which they, at this point in time, the city is entitled to, okay? These were all done pursuant to statute. They were all done, there was hearings, and the time periods for appeals have passed. So you're now into trying to resolve and clean up a matter. And the burden is on you to satisfy the city, and I think it might be good, and I don't know how that could be done, if that is acceptable to the city, that you all coordinate so that you could come forward and say, well, we are willing to, we've resolved this, and the city says that this, we'd like to do this, and, you know, and there would be $15,000 fines lien remaining on the property.
Yeah.
Okay, as opposed to a $53,000. But you want to wipe the slate clean, and equity says absolutely not in this case.
Yeah.
So I need something where I have something I can hang my hat on and say this is fair to all concerned.
Do you mind if I add one thing before we
Sure.
end? So I don't want to speak for staff. My job is to advise staff, but to explain the reason why up to this point we haven't come to an agreed upon settlement amount. It's because the city has not received evidence that was convincing to make that, like you said, a fair settlement. Right now, with the evidence we have, it doesn't seem fair to, you know, everyone else, right? And one screenshot of a superhost with a different name isn't convincing evidence. I could create a profile on Airbnb today saying I'm Josie Sue, right? That doesn't, and also, even if it was someone else, how do we know that they weren't receiving the funds or authorized that action? You know, I know of in different cities people that hire property managers. How do we know we didn't hire that person as a property manager to the property, right? There's just, that's not enough evidence for us to forgive a fine of this amount after being ignored and disregarded and allowing this to continue, and during that allowed continuation wreaking havoc on the community, so much so that we received complaints. If we were to settle and disregard the citizen's complaint, that would be disrespectful to the community. It's not just them that we have to consider, it's the community. How do we rectify that with the civilians who were harmed by this? They need to take that into consideration, and if they would like to present something to the city for resolution, I can't speak to what that is, but it needs to be more than what we've presented.
Okay. Well,
Okay, what is it that you guys need? Because
can't
I
get
don't
you
confused
need
know
to
what-
discuss with the city separately, okay?
And we can't give you legal advice.
And you can discuss
Oh.
if, for instance, as your realtor has stated, there may be an interest in trying to preserve this property as opposed to if it's sitting vacant, nobody is taking care of it. You know, all of these things can be factored in. There can also be somebody made some money. Okay, I have no idea who did, and I've seen these where sometimes, you know, rather than a $53,000 lien, it could be reduced to a lesser lien, which would.
That was ideally what we were wanting, if possible. Could I have Ken Strickland come in as well?
I have to have. Basically, that is generally worked out before you get here. And that has happened before, where people work it out with the city as to what would be inappropriate, because money in hand is always better than money that's sitting in a lien in the public records. Okay, so if there is something that can be worked out, that is also something, but it has to be acceptable to both parties. And in this case, it's the city and the current owner of the property. So with that said, I'm going to continue each of these. I have to do it individually. And then you can work out and, you know, contact, Ms. Diaz? Should they first start with the lady who they spoke with in?
Do you mind if I confer with staff for 1 second? Typically for these kind of reviews, do you mind if we take a brief recess, June? Could we step out in the hall?
Okay. The city has requested a brief moment of recess to resolve some procedural matters. It's 10:11, and I hereby call this proceeding in recess for the next 5 minutes.
Hi, Kenneth.
Okay. Yeah.
Well, at least they're continuing it.
Yeah, at least that much.
Yeah. I would like to see Ken Strickland, the one commissioner, come in, and he agrees to preserve the property, that we should just be reduced to maybe 15,000 or something left.
Right.
And then so it can be preserved. Now they're asking me to go back to June, the first lady I spoke with, and she was a positive no.
is 10:17, and the session, the June 23, 2026 rental program special magistrate proceeding is back in resuming. We're back in order. Do we still have our folks who were on Zoom?
Yeah.
If you could put them back on.
We're here.
Okay. Have you had an opportunity to discuss this amongst yourselves?
Yes.
Okay. As I said, if this, as was pointed out, this is not a lien review, it's miscellaneous business. But I'm really seeing it from the context of a lien review, because essentially we're trying to resolve an outstanding lien on a piece of property that is being an impediment to selling that property. I mean, it's an impediment only to the extent that the current owners don't want to give up that portion of the money to the city of Daytona Beach. Okay. Now you have indicated that the city may have an interest in this. First I've heard of the historical district being involved. And what I am suggesting, and what I would like to do, is to continue each of these 3 items for a month, give you an opportunity to get with the people who you feel have an interest with the city, so that I can get a feel for what the city's interest is in this property, and then make a determination based upon all of the facts that I consider relevant to resolving it.
Can I ask a question, please? You want us to contact the complainer, the person of the historic district? Yeah, I don't want to do that.
No, we don't. Those are water under the bridge. We've had people who complained about it, etc. That was part of what gives rise to the original fine. They're not going to probably change their story any. And what really it comes down to is the city and the property owner, and trying to find that whatever middle ground or whatever ground it is that can satisfy both of you, or at least give me some idea of what the city's interest is in this property. And obviously your interest would be to remove the entire lien. Okay. And at this point, I have no idea what the city's interest is, because they have a good valid lien on this property. And I'm not going to forgive a lien or a portion of it without knowing that the parties have done their best to try to work out some arrangement between them.
And again, I can't give legal advice, but I just wanted to help out and explain the procedure. So if you were here, I'd give you my card. I can read out my email if you prefer. I can have Mr. Yates read out his email. But what I recommend is, gather the evidence that the special magistrate requested. You could email it to us. You could email it to Lena, and Lena could send it to me. Okay, then.
I'm sorry, what evidence? You guys gave us the evidence.
Well,
this is public records.
I'm trying to help, but if you don't let me finish,
okay.
Please let me just. So any evidence you would like to present, there's different ways you can do it, whatever you prefer. Option 1 is you could send it directly to the clerk. She will send it to me and the special magistrate. You could send it to us directly. It probably would be easier to send all that to the clerk, who will forward it to all parties who should see it. If you want to set up a meeting to discuss, you're free to email me or Mr. Yates or anyone that you see fit. I'm just trying to help here clarify procedure. What I can't do is give you legal advice as to what you should present. The special magistrate, this is a recorded hearing. You can watch it back. I feel like numerous times you've detailed on what he would find convincing, but I can't give you legal advice, me personally, and neither can staff.
But yeah, we would be more than happy to meet based on any new evidence they want to send us that might present mitigating factors.
Okay. again, I want to say this is not a lien review, but I see it essentially as, because of the peculiar nature of this, as being a lien review. And you're asking the city to give up a good, valid lien and somewhere in the neighborhood of around $53,000 or some portion of that. And in return, there's a quid for the pro quo. It may be that the city has some interest in this property, seeing the sale take place so that the property can be maintained and kept up. Those are factors that only you and the city can discuss. And then if you bring that back before me, if I find that acceptable, then we can bring this to a close, and you can you can go forward with the sale of the property. So, having said that, I'm going to do each one of these individually and continue them until, what was the date again?
July 28th, 2026.
July 28th. Okay, July 28th, 2026. Okay. All right, so therefore, with respect to case number miscellaneous business 1, RTL 02-2424, Kenneth Metzler Jr., I hereby continue this matter to the July 28, 2026 special magistrate proceeding. With respect to miscellaneous business 2, RTL 05-2450, the respondent being Kenneth Metzler Jr., I hereby continue this matter until the July 28, 2026 special magistrate proceeding. With respect to miscellaneous business 3, RTL 07-2471, respondent being Kenneth Metzler Jr., I hereby continue this matter to the July 28, 2026 special master proceeding. Okay?
Okay.
Hopefully I've given you a
thank you.
roadmap to work this out. All right. Is there any further business?
Nothing further.
Therefore, it being 10:26, I hereby call this proceeding to be adjourned.